Has Mr. Aldridge made it yet? Not hearing him. Let's go ahead and skip to their current 48152 and hear that and allow Mr. Aldridge some time to get here.
Sorry about that. I just drove in from Houston. Traffic had been kind of delayed.
You're Mr. Aldridge?
That's correct.
Okay. Would you like a few minutes to kind of get your bearings and take another proceeding, or are you ready to roll right now?
It's fine right now.
Okay. Then let's call 49053 Vincent W. Aldridge.
Alex Feldman on behalf of the Commission for Lawyer Discipline.
Please proceed.
Mr. Vincent Aldridge was indicted and found guilty on 19 counts of crimes that involved moral turpitude. Count 1 was conspiracy to commit mail fraud and wire fraud. Counts 2 through 12 were aiding and abetting wire fraud. Count 13 was conspiracy to engage in monetary transaction and a criminally derived property. Counts 14 through 19 were aiding and abetting, engaging in monetary transactions and criminally derived property. And as you'll see, the petition was filed August 9th, 2011 with BODA. He was personally served on August 11th, and he has appeared. The original proof of service was filed with BODA September 1st, 2011. Mr. Aldridge has appealed his conviction, and so we are going to ask for an interlocutory order of suspension.
Mr. Aldridge, would you like to make a brief opening statement?
Yes, all he said is true. I have been convicted, and we are pending appeal. I understand what the rules say, and ultimately it being a crime of moral turpitude. I don't want to really belabor the time, so what I'm going to do is explain my position and then let you know why I showed up here today. For the most part, I've practiced, I guess, about 15, 16 years now. I never had a problem with a client in a circumstance where I had a grievance that actually flown to the point to where it was a grievance. I may have had 1 or 2 inquiries. Basically, I owned a title company. And as a title company owns a small business, for the most part, there were some transactions that took place in that title company that ultimately implicated me. Because it was a small circumstance, and I actually knew the person who was the mortgage broker. Actually, we went to law school together for 1 year. He didn't finish, but I knew him, but I didn't hang out with him. Basically, I was convicted of aiding and abetting those transactions. And ultimately, this case has been appealed. I understand it's an uphill battle with these circumstances. But the reason why I showed up here today is this, that I represent clients right now in criminal matters. I have a few clients that I'm trying to wind down the docket. I only take court appointments. I don't take money from retained clients. I was here today basically to ask, I understand that this suspension is probably inevitable, and eventually if the appeal doesn't go in my favor, disbarred. I have no problem with that. I understand the rules. What I am asking is this, is that possibly any way that the suspension can be placed at a date that's commensurate with my date to report to federal prison, which is November the 21st. That will give me an opportunity to service these clients who don't have a problem. They are court appointed, and within that period of time, I believe that I can clean up everything, or I will be forced to have to withdraw immediately, and that will cause some hardship to some of them. That's the reason why I'm here, and like I said again, that date is November the 21st. So if that's something that can be asked for, or can be granted within your power, I ask that that be done. Thank you.
Thank you. Mr. Veltman?
May I approach?
Yes.
I would just like to offer Exhibit 1, which is the indictment in this case. That's a certified copy from the court.
Exhibit 1 is submitted.
And
Do you have, I'm sorry, do you have any objection?
No objection.
Exhibit 1 submitted.
And other than that, I'd like to point out that 804 requires that since he has been found adjudicated guilty, and I believe Exhibit 1 does have the judgment. No, Exhibit 1 is the indictment. Getting ahead of myself. Exhibit 2 is also a certified copy. It's the judgment. I would offer that.
Do you have any objection to Exhibit 2?
No objection.
There being no objections, Exhibit 2 is submitted.
Exhibit 3 is my affidavit stating that I believe Mr. Aldridge is the same person who was indicted and found guilty in this underlying charge. I would submit that.
Mr. Aldridge, any objections?
No objection.
And then
Exhibit 3 submitted.
Thank you. Exhibit 4 is the Blake Hawthorne letter stating that Mr. Aldridge is licensed and authorized to practice law in Texas. I'd
Any
offer that.
objection? There being no objections, Exhibit 4 is submitted.
So just to close, Texas Rules of Disciplinary Procedure provide that under 804, that once an attorney has been adjudicated guilty of a crime involving moral turpitude and appeals that judgment, then he should be suspended pending appeal. I would ask that the board do that. Thank you.
Any further comment? Mr. Aldridge, we appreciate your request, and we'll take this matter under advisement. And
Mr. Veltman,
Yes, sir. I'm sorry.
do you have any comment on his request that the suspension become active in November?
I don't believe that I have authority to enter into that sort of agreement from my client.
I'm not really asking about your authority. What I'm asking is, do you have a legal comment in regard to his request that the suspension become active in November?
To be frank, I am not aware of any case law that allows for that or statute that allows for that, and I have not researched that issue. So if you would like me to do that and provide something by this afternoon, I'd be happy to do it. But I profess ignorance as to that particular request.
I have a question as well. It's really for Mr. Aldridge. Mr. Aldridge said November 21st was the day that you're supposed to report. As I'm looking at what I believe to be Exhibit 2, it says that you shall report by the 15th of November. Is there something that's changed since that exhibit has come out?
The date that I was given was the November the 21st. That may be correct, but the document that I actually had was November the 21st, 2 p.m. in Louisiana. Don't get me wrong, I've received something subsequent to that, right after he said that, saying report, which would have been a month ago. So it has been some discrepancy, but the date that I'm showing is the actual 21st. That date, I haven't actually looked at the date that you have. If it's the 15th, there may be some discrepancy, so
I'm looking at the document that I believe was signed on July 26, 2011 by Sim Lake, which reflects the conviction as of January 26, 2011. And I'm looking at the PDF for whatever it's worth. It's the third page of 8 for document 207 in your criminal matter.
Okay.
And under the topic of imprisonment, it says defendant shall surrender for service of sentence at the institution designated by the Bureau of Prisons not before November 15th. I just want to make sure I understand what date you're talking.
It was the 21st was the judgment day.
Mr. Aldridge, are the court appointments that you talked about earlier in state district court or in federal court?
They in state district court, and they are aware of my circumstance. Every client is. The judges actually that I've before have explained their circumstances because one of them actually the federal court sent, one of the prosecutors sent, and I had to deal with it. And basically the judge asked my client if it was okay, and were they aware, and my client still wanted me to represent them.
How many matters are you talking about?
We're talking about 5 matters. 5 matters. And
I recognize that by you pending imprisonment while you're handling these matters, the continued handling of these matters may give the clients an additional ground to appeal whatever result is in their case.
That's been discussed. The judge asked the prosecutors, actually specifically in the case, would that be a concern, and asked them to produce them some law, which I haven't heard of any as of yet concerning it. So the judge maintained me on the case ultimately, and basically I haven't heard anything otherwise as a circumstance of that.
Will those 5 matters be concluded by November 21st?
A couple of them will be, for sure. The other ones, I'm going to actually wind down and possibly end up having to withdraw if they extend beyond that time. So it does give me a time for them to be able to choose and do what they need to do, and me to properly go through and necessarily withdraw and make sure that they got everything that they need from me and everything to that.
Is there anything that prevents you from withdrawing from all 5 of them at the present time?
Nothing to prevent it, but I think it would be a hindrance to a couple of clients. I have some motions that have been really just recently filed in the case that ultimately I filed them. I think it would be better if I articulate them, and I think it would definitely hinder the case if it wasn't me representing. That's just my opinion. I ain't trying to think too highly of them, but basically I think in a couple of cases it really would hinder it.
Any other questions?
You said you are on appeal to the Fifth Circuit?
That's correct.
What's the status of the appeal? Have
Basically,
the briefs been filed? Or?
No, notice has been filed.
Okay.
No appeal has been filed as of yet. I tried to stay away from the talking about the case so much because I didn't want to come here and bore y'all. But if y'all have any questions that y'all want to ask me, it's not because I'm trying to withhold any information from you. I have my opinions about it. I've been practicing law for some time. And I'll go on record right here, just like I did at the federal court, and say, I ain't never stole nothing in my life. And the bottom line is that ultimately, I think, as appeals go, I think that I would have a better appeal than most people because I was an attorney sitting there and saw specifically what was said and what happened.
Other questions? Mr. Belton, selected.
One final comment, if I may, that the commission does oppose this motion or request primarily because the rules were put in place to protect the public, and if someone has been adjudicated guilty, 19 counts, adjudicated guilty of crimes of moral turpitude, then there is some question as to his ethical standing or his ability to comply with the disciplinary rules, and question as to how he's going to treat his clients and behave to protect the community as well as his clients. So with that being said, I would say that the commission does oppose it.
Yeah.
Mr. Veltman, you had mentioned that you weren't aware of any cases that said the board could grant the request that he's asked for. Are you aware of any cases that say we cannot?
No, not at all. I have not researched that issue.
Mr. Veltman,
I have not seen anything. Obviously, that the rules don't state that you can postpone it, but I have not researched case law at all.
Mr. Veltman, do you have any information to address Mr. Aldridge's assertion that his trial court judges are aware of the fact of his pending imprisonment or of any of those proceedings or the results of any of those proceedings based on whether or not those trial court judges are aware of the facts of this case?
No, and we have not done, I have not done much investigation of this case. I haven't heard from Mr. Aldridge until this morning when he called and said that he was going to be late. He didn't answer. I didn't think he was going to be here. I didn't know what was going on with, that he even had cases that were pending, so I have no information on that at all.
Any other questions? Yes.
As I understand it, these are all criminal appointments?
That's correct.
All criminal appointments?
That's correct.
Pro bono, you said?
No, not pro bono, court appointed.
Court appointed. Mr. Velvet, what is your concern about the public not being protected for these 2 months under those circumstances?
Statutorily, if someone is convicted of a crime of moral turpitude, then they are to be suspended pending the appeal. Aside from that, from my experience, and well, let me not comment on my personal experience, but if someone is convicted of a crime that casts doubt on their ethics and casts doubt on their ability to comport with the rules of society, then it also casts doubt on their ability to protect the interests of their clients, either from other people or from their own ethical problems. So the fact that there's 19 counts of basically theft-related cases makes one wonder exactly what else he might do. And he may be innocent. It's on appeal, so I can't comment on that. I'm not here to attack the judgment or uphold the judgment. I'm not the appellate court. But the fact that someone has been adjudicated guilty of these theft-related offenses automatically casts into doubt his ability to protect the interests of his clients or his ability to protect the rest of the community from his own interests. And like I said, I was not the jury, I was not the judge, I do not know Mr. Aldridge, so I'm not trying to comment on his personal specific situation, but from a standpoint of why we have these rules, then I believe that it's appropriate that we suspend him.
Mr. Aldridge, what kind of cases are these you've been appointed to?
Burglary case, one of them, criminal matter. One of the couple cases is burglary. One of them possession case. The other three matters, one is basically a case in which I think I'm trying to recall off the cuff. I have a client that basically is charged with deadly conduct, and I think the other was just peripheral matters. I can't recall exactly what it is, but those are the three major ones. Really, the burglary case out of Fort Bend County and the actual possession case are the ones that actually I filed and were set for trial and pretrial matters. Those are the ones in which I'm mostly concerned about. I feel basically I've taken a unique position with these clients, and what I mean by unique is this: if it had not been for me, they would have been pled to these cases and actually ultimately taken charges, which I felt that the law would not allow. Basically, they are standing ready. The prosecutors basically, and I'm just going to go and say the federal prosecutor sent to the court, and that's why the court knows, to the court, and a motion was filed. And a motion was filed that we had dealt with specifically in these cases. And ultimately, they're trying to remove me because I'm the only thing that's standing between them, they feel, and these clients being able to take a plea. And I'm not saying it because I feel like that I'm the best attorney in the world. What I'm saying is that ultimately, I understand that they need somebody who's going to try to defend their rights, specifically in light of my own circumstances. And I feel that if I remove myself from this position now, they'll come in and offer them a better deal, and basically they'll end up taking it when I don't believe that ultimately the facts warrant it. I think that one of the cases need to be dismissed. And I think the law supports it.
I'm sorry, I didn't mean to. Ms. Aldridge, the information's in here, I missed it. Were these appointments undertaken before or after your conviction?
I believe that they were undertaken after my conviction. Some of them, I think one of them may have carried over from that aspect, but I think the majority of them have. If I can't speak to what he said, I kind of already had. Basically, I understand the state's position. I would have that same concern. But if I could taper that concern, it would be this. I said specifically flat-footed that I never stole anything in my life. That's not my issue. I've practiced law in this state blameless for a number of years. I've never had a client complain concerning it. And in this case, it's not a client that's complaining. It's a circumstance in which, as you can see, I was convicted of aiding and abetting, but I was charged as the principal. But it turned out to be that I was aiding and abetting, and that was through my business relationship with a person who basically committed mortgage fraud. Ultimately, that's on me. It wasn't my intent to commit mortgage fraud, and that's where the problems lie, and that's basically the issues that we're dealing with, among some other things concerning appeal. As far as the public goes, I've stated that my clients, they know my circumstance. Now, that's a hard situation to be out in front of court, in open court, doing just like I'm doing right now. But I'm immune to such because, see, I know that ultimately what they accused me and what I was convicted of ultimately was not what I did. And I'm not saying that I'm not appreciating the fact that I have been convicted, because I understand that I am to follow the law, that I am to respect the law, and I do all those things. And I will report to federal court on the 21st if that's the case. What I'm asking is that suspend my license. I understand his position, but let me have an opportunity in between this time to try to get rid of these cases. They're set for trial too, and that's really the main issue. They're set for trial, and the trial date is in between that time. And I would hate to have to withdraw at this point, specifically in those two cases, and leave them hanging only to have to get another attorney to start this process all over again or whatever. And that's really the crux of the matter, based on the pretrial motions that have been filed in the case.
Any other questions?
Yes, I've got a couple here. Mr. Aldridge, as I understand, you were convicted last January.
This past January.
And you've taken 4 out of the 5 cases. You've accepted them since then, knowing of your conviction on 19 counts.
That's correct.
And you were sentenced in July?
In July the 22nd.
And why is it that you haven't withdrawn in all that time? Or why did you accept the cases to begin with?
Well, number one, and this is going to be hard. I'm just going to tell you the way it is. When you get indicted in the federal court system, the first thing they do is attack your ability to fight, your income. As you can see over the last,
I'd like to take a few minutes break. We can go in recess and give you a few minutes, and then come back and let you finish your statement if you'd like.
Thank you.
5-minute recess. We'll come back at 10 after 10. Mr. Aldridge, go ahead.
I think, Mr. Smith, your question was, why didn't I withdraw? Basically, I needed the money to support my family. And why you saw me start crying, and man, it takes a lot for me to cry too, I must say that, was because, and I didn't come here to get into all of this. Under these circumstances, I've had a kid born, and I've seen it die prematurely, born still alive, but yet died too early. I've seen another kid born the same month, 5 months too early, that's in the NICU unit right now, that's thriving, that was born 1.3 ounces, and now 5 pounds. I thank God. That's why I was crying, because that's why I need to maintain. And basically what I'm doing now from an economic standpoint is just maintain, barely. So to answer your question, it was because I needed the money to basically support my family.
Any other questions of Mr. Aldridge? Mr. Aldridge, we appreciate your being here and addressing us, and appreciate the frankness and candor you've shown the court. And the request under advisement and inform the parties of our decision.
Thank you.
Can I be a student?
Yes.